Uh, Good morning. In today's session, we are going to learn chapter 2 of Companies Act 2013, that is incorporation of company and matters incidental thereto. In this chapter, we are going to explain the formation and incorporation of a company, whether it is private limited company, public limited company, OPC, or Section 8 company, that is not for profit organization. Then we will identify the need for memorandum of association and article of association and any alteration incidental thereto. We will understand. We will know the effects of registration. We will explain and identify the concepts related to registered office of the company. We will understand how documents may be served and filing thereof. We will understand the authentication of documents, proceeding and contracts and execution of the of exchange, etc. In the scope of this chapter, we will categorize this chapter into core categories. First one is formation and incorporation. Then second one is YAML and AOA. Third category is of documents, and fourth one is of other provisions. In the first category, that is formation and incorporation of company, we will see section 3, then section 3A. In section 3, we will see the corporation of company. In section 3A, we will see the members severally liable in case of reduced members. Then we will see section 7. In section 7, we will see which documents to be filed with RSC for the incorporation of company. Then we will see not-for-profit company, that is section 8 company. Then we will see the effects of registration under section 9. After this, in the second category, we will see MOA and AOA. In MOA under sections 4 and AOA under section 5. We will see Act to override MOA and AOA under section 6. Then under section 13 and 14, we will see alteration of MOA and AOA respectively. Then we will see updation of changes to be noted in every copy of MOA or AOA under section 15. Then we will learn how to give copy of MOA and AOA to members and the mandatory condition to give copy of MOA and AOA under section to members under section 17. Then you will see documents in the third category of documents. You will see the service of documents under section 20, then authentication of documents under section 21, and execution of documents under section 22. In other provisions, we will see the commencement of business under section 10, registered office under section 12, rectification of name under section 16, the conversion of company form from one form to the another form under section 18. Then we will see subsidiary can't hold shares in holding under section 19. Now, in introduction of incorporation of companies and promoter, this chapter covers sections from 3 to section 22, as well as the Companies Incorporation Rules 2014. A company is a separate legal entity from its members. It has a perpetual succession, and it can be incorporated only for lawful purposes. Prior to incorporation, promotion activities are essential. Promotion signifies a number of business operations familiar to the commercial world by which a company is brought into existence. Persons who undertake promotion activities in order to incorporate the company are generally known as promoters. This section, the section 2, clause 69 of the Companies Act 2013 deals with the definition of promoter. It says promoter means, it's an exhaustive definition, means a person who has been named as promoter in a prospectus or who is identified as a promoter by the company in the annual return under section 92, and who has control over the affairs of the company directly or indirectly, whether as a shareholder or director or otherwise, or in accordance with its advice, direction, and instruction, the board of directors of companies accustomed, that is, in accordance with direction, advice, direction, or instruction, the board of directors of the companies are accustomed to act, but shall not include a person who is acting merely in a professional capacity, such as attorney, technical, or functional experts. Students are advised to take note that the above definition serves the purpose to make a person liable in capacity of promoter or caught through misstatement, but not highlight what actually promoters do. Hence, considering the judicial pronouncement improves our understanding regarding the role of promoter. Promoter is one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary step to accomplish that purpose. To be a promoter, one need not necessarily be associated with the initial formation of the company. One who subsequently helps to arrange floating of its capital, helps to arrange floating of its capital, will equally be regarded as a promoter. Hence, promoter denotes any individual, association, partnership, or a company that takes all necessary steps to incorporate, create, or mold a company and set it going in a fiduciary position. Now, statement. To be a promoter, one necessarily be associated with the initial formation of the company. False. One who subsequently helps company to keep going, raise funds, advise to board, other than in a professional capacity, will equally be regarded as a promoter. Now, we'll see section 3. Section 3, that is the formation of company. We will see section 3, subsection 1, and section 3, subsection 2. In the pre-independence era, companies were granted rights by royal charter, but now a company is incorporated by either a special act of the legislature or under the Companies Act 2013. Accordingly, an incorporated company may be either chartered company or statutory company or registered company. Section 3 of the Section 3 of the Act deals with the registered companies. First one, forms of companies. The companies are broadly classified into categories shown in the below figure. There is a company that is categorized into incorporated company or unincorporated companies. Incorporated companies are further divided into three types based on the liability mode of registration. Based on the mode of registration, there are three types: registered companies, statutory companies, and chartered companies. And on the basis of liability, registered companies are further divided into limited by shares, limited by guarantee, and unlimited company. Limited by guarantee and unlimited company are further subdivided into two types, with capital and without capital. And all these categories further subdivided into public and private companies. Now we will see subsection 1 of section 3, which provides that for lawful purpose by subscribing their name to memorandum and are complying with the requirement of this act, a public company may be formed by 7 or more persons. A private company may be formed by 2 or more persons. A one-person company, which is a private company, may be formed by one person. Further, subsection 2 to section 3 provides that a company formed as specified above may be incorporated either as companies limited by shares or companies limited by guarantee or unlimited liability companies. Or limited liability companies may be companies limited by guarantee as well as shares, but specified IFC's public and specified IFC private company shall be formed only as a company limited by shares. IFC company means a company licensed to set up business in any international financial service center. IFSC in India, example is GIFT City, Gujarat International Finance City. Now we will see one-person company. When we discuss about one-person company, the Companies Act 2013 for the first time allow the formation of company by just one person with limited liability. called one-person company. Such a company is described as a private company under Section 3, subsection 1, clause C. Further, Section 3, subsection 1, along with Rule 3 and 4 of the Companies and Corporation Rules 2014, provides certain provisions specifically applicable in case of OPC one-person company listed below. Who can form one-person company? The person, only a natural person who is an Indian citizen can form OPC, and he should not be a minor. Okay, now only a natural person other than minor who is an Indian citizen and whether resident in India or otherwise. So residential status is immaterial for the person to be eligible to form a OPC. Form an OPC, let's say, shall be eligible to incorporate a one-person company. Resident in India means a person who has stayed in India for a period of not less than 120 days during the immediately preceding financial year. OPC can be incorporated or converted into company under Section 8 of the Act. Further, OPC can carry out non-banking financial investment activities, including investment in securities of any body corporates. Now indicate name and consent nominee. A member of OPC need to assign nominee for the company to maintain the perpetual succession in case of his death or incapacity to contract. Alright. So the the nominee will become member of the OPC. Okay, now the indicated the name and consent nominee. The memorandum of OPC shall also indicate. So for private and public company, there is no nominee clause in their memorandum, but in the case of OPC, its memorandum shall also indicate the name of the natural person other than minor who is an Indian citizen, whether resident in India or otherwise, as a nominee along with his prior written consent. We need a prior written consent of the nominee who is Indian citizen and who is other than a minor, and should be a natural person, whether resident in India or otherwise. So resident is also status is immaterial for nominee of OPC also, but along with his prior written consent in a requisite form. I think this form is INC3, of who shall, in the event of the subscriber's death, subscriber means who later on after registration become the member of the OPC, and in the event of the members or subscriber's death or his incapacity to contract become the member of the company. Now note the provision is to ensure perpetual. So here they have mentioned this provision is to ensure perpetual succession of legal existence of OPC. We take an example over here. Ms. Madhu form an OPC wherein Mr. Sudan is nominee as his name is specified in amount along with his consent. Ms. Madhu declared insolvent. She become insolvent. So her the event of in her incapacity to contract, pending to discharge insolvency, she becomes incompetent to contract, hence Mr. Sudan becomes a member of such OPC. The name of the such nominated person in form the name of such nominated person in form number INC 32, that is vice plus form, along with the consent, which his or her consent of such nominee, obtained in form number INC 4. So this is consent we have to take in INC 4. Okay. And he as provided in Companies Registration Office Fees Rules 2013 shall be filed with the registrar at the time of incorporation of the company along with its memorandum and articles. A natural person shall not be a member of more than one person company at a point of time, at any point of time, and the said person shall not be a nominee of more than one person. So there is a condition at any time, at any point of time, a person cannot be a member of two OPCs more than one OPCs, and he cannot be a nominee of more than one OPCs at any time. These are sub-rule 2 and 3 of Companies Incorporation Rules 2013 related with OPC, where a natural person being a member in OPC in accordance with the rule 3 sub-rule 2 becomes a member. Sub-rule 2 and 3, these are the sub-rules. Another rule 3 sub-rule 2 becomes a member in another such company by virtue of his being a nominee in that one person company. Such person shall meet the above specified criteria, means can be a member of only one OPC within a period of 180 days. So he got a period of one, he will get a period of 180 days in which he has to decide it in which OPC he wants to be a member. He has only one choice. He have to take the decision in which OPC he wants to be continue to be member within 180 days from the date in which he come to this condition or this situation. Okay. Now, withdraw of consent by nominee. A nominee can voluntarily withdraw the consent as a nominee in OPC. See, there is a procedure. Such other person, that is nominee, may withdraw his consent by giving a notice in writing to such sole member and to the OPC, that one person company. In the case, the sole member shall nominate another person as a nominee within 15 days. So once, let's say I'm the member of OPC and Maidi is a nominee of my company, OPC. And if she give me the withdrawal of consent, then after receiving that consent, within 15 days from that the reception of the consent, I have to assign new nominee for my company, for my OPC company, of the receipt of the notice. Once I receive notice of withdrawal from my former nominee, I have to choose the latter nominee within 15 days on the receipt of the notice, and shall send an intimation of such nomination in writing to the company. Then we have to send an intimation of such nomination in writing to the company, along with the written consent of such other persons so nominated in a form of declaration in form number INC4. Okay. Now, despite the name of such other old nominee and another person new nominee specified in memorandum, any such change in the name of the person shall not be deemed to be alteration of memorandum. In section 13, we will see the alteration of memorandum. For making any alteration in a memorandum, we need to pass a special resolution. But in case of OPC, in the memorandum, there is a last clause, that is a nominee clause. So as we change the nominee, either by accepting the notice of withdrawal from the nominee, or by removal of nominee, it will not alter the memorandum. Originally it will, but it will not be considered, or which shall not be deemed to be an alteration of the memorandum as per section 13. Okay. Now, replacing nominee with another one. Now, if member wants to replace the nominee, then he can do so by the following this procedure. The member may change the name of the person nominated by him at any time for any reason, including in case of death or incapacity to contract of nominee, and nominate another person, new nominee, after obtaining prior consent of such another person. So if I have a nominee one, this is now OPC nominee. This is not, not, let's say not will be my old nominee. I want to replace him. There may be different reasons to replace him. Either he will be dead, or he is incapacity he's in the event of incapacity to contract. Then I will assign N1 as a my new nominee. A member can do by giving intimation in writing to the company. So for that, I'm the member. I will give the company intimation that I want to change the new nominee. This is not specified either in Act or rules whether the intimation shall be prior of making change or can be made afterward. But if we consider reasonable construction, the intimation shall be prior intimation. In law, they have not mentioned whether you have to give intimation to the company mm, before the change, before the changing of replacement of nominee or after the replacement of nominee. But it can be construed, reasonably construction is there, the intimation shall be a prior intimation. So any such change in the name of the person shall not be deemed to be an alteration of the memorandum. And this also shall not be deemed to be an alteration of the memorandum. Now, Rajesh has formed an OPC. We'll take an example. Rajesh has formed an OPC one-person company wherein his wife Rupali is named as nominee for the last 2 years. When his wife Rupali is suffering from terminal illness and due to this hard fact, he wants to change her as a nominee. So he has a trusted and experienced friend Ramnivas who could be made nominee or his Raj's son Rakshak who is of 17 years. He is a minor of age. In this instance, Rajesh can appoint his friend Ram Nivas as the nominee in his OPC, but not Rakshak because Rakshak is a minor. Now, when nominee become member, where the sole member ceases to be the member and nominee becomes new member, where the sole member ceases to be the member and nominee becomes new member, then such new member shall nominate within 15 days of becoming member a person, new nominee, who shall, in the event of his death or his incapacity to contract, becomes a member of such company. Notice of change to registrar. When nominee becomes member, sole member ceases to be the member or nominee becomes member and nominee becomes member. Then such new member shall nominate within 15 days of becoming member a person, new nominee, who shall, in the event of his death or his incapacity to work, become the member of such company. Notice of such change to registrar. In all the three cases of change discussed above, either withdraw of consent by nominee, replacing nominee with another one, and with nominee becomes member by in the event of the previous member suggests to be a member due to the death or incapacity contract. The company within 30 days of receipt of notice of withdrawal of consent by nominee or intimation of change in nominee or members or cessation shall file the notice with registrar of such withdrawal of consent, change or cessation, uh, respectively, and intimate the name of such another person, new nominee, in form number and C4, along with the fee as provided in companies, registration offices and fees, rules 2014, and the written consent of such another person so nominated in form of declaration in form number INC4. Now, we will see true and false. Even a non-resident Indian and becomes a member of OPC, no. He should, yeah. Residential status is immaterial. The non-resident Indian can form OPC because he is a national person, he is a major, and he is an Indian citizen. But he's not resident, so residential. Anyhow, residential status is immaterial to form a company. So, yes, as per Rule 3(1), Clause C of the Companies Incorporation, Rule 3, Sub-Rule 1 of the Companies Incorporation Rule 2030, only a natural person other than minor who is an Indian citizen and whether resident in India or otherwise shall be eligible to incorporate OPC. Now, there is some additional reading that we need to understand why people prefer to form OPC. People, not a person who wants to be the member of a OPC, why we choose to form OPC that we will see. There are some relaxation available to an OPC. First, not required to prepare cash flow statement. We will see in advanced accounting cash flow statement or in accounting standard 3, that is cash flow statement, that the OPC, then startup private company, then small company and dormant company. This company do not need to form cash flow statement with effect of section 2, subsection, to section 2, clause 40. That is the definition of financial statement. Now, the annual return to be furnished under section 92 can be signed by the director and not necessarily a company secretary. Even average annual return may be prescribed. OPC, when high annual return, there generally when you file an annual return, there must be a sign of one director and a common secretary if there is a common secretary in the company, or the sign of two directors. But in case of uh, in case of OPC, there is no need of a sign of company secretary, and even a breach annual return can be filed by OPC. This relaxation the OPC has. And further, following the similar line, Section 134 provides it would suffice if one director signs the audited financial statement and a breach form of director's report may be prescribed. In OPC, a single person, single director can sign this statement. Now, holding annual general meeting as required under Section 96 is not necessarily in case of OPC. OPC need not to conduct annual general meeting because there is only single member. There is no sense to conduct such meeting, hold such meeting. But moreover, certain specific provision related to general meeting and extraordinary general meeting specified under Section 100 to 111 may not be applicable to OPC. Okay. Now, even relaxation is also there in convening board meetings. Section 173 requires an OPC to hold only one board meeting in each half of a calendar year, one January to June, July to December. So there is within each half of calendar year, you have to hold one board meeting. White Section 137, the OPC are allowed to file financial statement within 6 months from the close of financial year as against 30 days. So for other company, generally they need to file their financial statement within 30 days from the close of the financial year. But for OPC, we have the time limit of 6 months from the close of the financial year to file financial statement. Now we will see Section 3A in our next video. Thank you.